Good morning, afternoon and evening, everyone, and welcome to the 2021 annual lecture of the UNSW Allens Hub for Technology, Law and Innovation. I'm Professor Andrew Lynch and I'm the Dean of UNSW Law and Justice, and I'm really delighted to welcome you all today. I would begin this session by acknowledging the traditional owners of the lands on which we are respectively gathered. UNSW's main campus is on Bejigal land, and I pay my respects to the elders past and present of those people. I also extend a particular welcome and respect to any Aboriginal and Torres Strait Islanders who are present in the audience today. The UNSW Allens Hub for Technology, Law and Innovation is an independent community of scholars based at UNSW Sydney. As a partnership between Allens and UNSW Law and Justice, the Hub adds breadth and depth to research on the diverse interactions amongst technological change, law and legal practice. The partnership really enriches academic and policy debates and drives considered reform of law and practice through engagement with the legal profession, the judiciary, industry, government and the broader community. We are immensely grateful to our friends at Allens for our ongoing collaboration with them through this initiative, and indeed to other support that the firm very generously provides to the faculty and its students. It's my pleasure now to introduce Gavin Smith, a partner at Allens deeply involved in the Hub's work. Gavin is head of the Allens National Technology, Media and Telecommunications and Data Practice. Gavin has been recognised by both Chambers Asia Pacific and Legal 500 as a leading Australian lawyer in this field. Thank you, Gavin, for all of your support for the Hub, and now over to you.
Thank you very much indeed, Andrew. And I would also like to take this opportunity to say that we at Allens also acknowledge the traditional owners of country throughout Australia and recognise their continuing connection to land, waters and community, and we pay our respect to their elders, both past and present. It's a great pleasure for Allens and for me to have the opportunity to co-host this event together with UNSW, Andrew, and with Lyria. Over the past 3 years, the UNSW Allens Hub has produced an incredibly broad and valuable body of research and insight into how the law responds to the dramatic changes impacting our economy across multiple sectors. It really is a partnership with which we at Allens are incredibly proud. We're lucky to have the opportunity to be involved with academics and research of such an interesting and high caliber. It brings joy to our practice of the practical application of law. I'm sure most of you in the audience will know Allens and who we are. We are the country's oldest continuously operating law firm, and in fact, we are this year commencing our preparations for our 200th anniversary in 2022, next year. We've seen a lot of change in that time, of course, from the first gas lamps in the street in New South Wales, the first bank in Australia, all the way through to conducting sessions like this on a global basis on a virtual platform. That pace of change driven by technology is, I think, faster and more dramatic now than it has perhaps ever been. And that, of course, has a continual effect on law and regulation, both the theory of law and its practical application. And so for that reason, I'm very much looking forward to listening to Roger tonight, this morning, this afternoon, wherever you are. We here at Allens spend a lot of time at our desks thinking about how current laws and regulation are applied. So to stand back and to hear about how to rethink law, regulation, and technology is a very welcome opportunity indeed. Thank you very much to you all for joining us, and I will hand over to Lyria to introduce Roger.
Thank you very much, Gavin, for that introduction, and to Allens for all of their support, both intellectual and financial, for the UNSW Allens Hub. And I'm also very excited about the 200th anniversary. It's not many institutions, particularly in Australia, that can claim that kind of longevity. So well done to Allens on that milestone. I'm also very excited to have Roger virtually here beaming in at a ridiculous time in the UK in order to deliver this lecture. I've been a long-term admirer of Roger's work, particularly the deep thinking he demands around the use of technologies in regulation and the questions that he asks. Roger has professorial positions in law at King's College London and at Bournemouth University, as well as honorary and visiting appointments elsewhere. His most recent book, Law 3.0, Rules, Regulation and Technology, and his forthcoming book, Rethinking Law, Regulation and Technology, will hopefully form part of the conversation to follow. I'm not going to do an extended introduction because I'm assuming you're all here because you know what's coming. I would like to invite you, as Roger is speaking, to put your questions in the Q&A, and I will get to as many of those as possible after Roger concludes the initial presentation. And with great gratitude, Roger, over to you.
Well, thanks very much indeed, Lyria, and everyone. It's very early in the morning here in the UK, but so good very early morning to everyone. I'm going to talk about rethinking law, regulation, and technology. I can only skim the surface of what's coming up in the book, but I know in the Q&A we'll have a chance to talk some more about that. And I mean, this is just the beginning of a conversation, so it won't be done today. But I'm going to start by presenting three small pictures of the relationship between law, regulation, and technology, a kind of 1960s picture, a 1990s picture, and a 2020s picture. And the 1960s picture is the picture that I first had of law, regulation, and technology when I started my legal studies in London. Now, although at that time, the UK government was talking quite a lot about the white heat of technology. Harold Wilson gave a very famous speech in the early 1960s about that. The white heat of technology did not seem to have burned its way through to the law school. And I mean, maybe I was dozing too much in lectures, but our classes, I just did not hear anybody suggest that technology was significant or salient for us law students. I mean, on the contrary, we were encouraged to think inwards. Lawyers should be interested in law. Technologists, no doubt, were interested in technology. And I often think that if someone had had the bright idea back then to bring lawyers and technologists together at some sort of dinner party, they might have had interesting conversations, but it wouldn't have been about law and technology. And regulation, well, I'm not sure when regulation did come onto the map, but I don't think, again, that was on the map then. So, technology in the 1960s was neither salient nor significant for lawyers. Now, in the second picture, in the 1990s was a really important decade for the development of technology and for, I think, the development of a sort of connecting view between law and technology and regulation too. Because in biotech in the 90s, of course, huge strides were being made in relation to genetics and in information and communication technology. I mean, by the end of that decade, we could see what e-commerce perhaps was going to look like. So that was very important developmentally. Now, lawyers and regulatory scholars in the 90s, insofar as they were interested in technology, were beginning to see it as salient and significant. But two things about this. One was they saw technology as being, so to speak, out there. There was law and regulation here, wondering how to engage with technology out there. And it was puzzling and challenging and problematic, whether you were a kind of traditional private lawyer or whether you were someone, in the vanguard of regulatory thinking. How were lawyers and regulatory people to engage with technology? For lawyers trying to rework traditional principles or concepts like property or, principles of contract and tort law, it was challenging because, of course, these principles and concepts, although they were flexible, weren't designed for a world in which these kind of technologies that we were now looking at were in place. And for regulatory scholars too, well, Lyria, you yourself actually were one of the first people to write about the problem of, the pacing problem or the connection problem or the sustainability problem, that law moves in a relative, first gear, and technology has a different gear altogether. I often think it's a bit like, at a wedding where the photographer wants to try and has a photograph that captures everybody at the wedding party. And, he's encouraging them to all herd together and stand still just for a second. And this is a bit like lawyers and regulatory scholars who are trying to just capture state-of-the-art technology at that moment. And you know, as soon as you've taken that snapshot of it, technology is going to move on, and that snapshot is going to look dated, and particularly where the snapshot is then the basis for a legislative intervention. You know that legislation is soon going to be out of touch with the technology. So that's a problem. But it wasn't just that. In biotech, particularly in Europe, well, not just in Europe, but biotech was resurrecting old values, particularly about human dignity, questions we hadn't really been asking ourselves about ourselves, and was highly divisive. So you see, a real plurality of views about genetics and the way it should be governed. And of course, in information and communication technology, in the beginning of the internet, there was a seminal article by David Johnson and David Post in the 1990s in the Stanford Law Review, in which they warned national regulators that there were problems ahead because cyberspace just doesn't map onto land-based legal systems in the way that you might want it to, and so it's going to be problematic. And although, I think one of the early conflicts cases came to Australia and just after the end of that decade, but all around the world there were going to be problems about maintaining regulatory effectiveness when goods and services could just be supplied across borders without regulators having any real purchase or handle on that. So that was a very important decade. But the crucial thing to take away from that is that the technology was out there, and we lawyers and regulatory people didn't really know quite how to engage with it. It was a problem. Now we come to the 2020s, and it's very interesting too. The 1990s view is still there, and an awful lot of scholarship in our field, law, regulation, and technology, is in that particular genre. Lawyers and regulatory people thinking about how to engage with these emerging technologies, whether it's anything from 3D printing to AI and machine learning, blockchain, whatever it might be. The questions are, how do we apply the regulatory and legal apparatus that we have to these upcoming technologies? But in the 2020s, let's say, there is now an interesting flip, because it's been there. It's been there since the late 1990s, when Lawrence Lessig wrote some very seminal pieces about this. But the idea that technology, the tools that the technology has now, are not just out there to be regulated, they are themselves potentially applicable as tools of governance. This is the crucial turn. So we have all sorts of technological options, technological fixes, which we might try to apply, along with the rules and standards and principles, which have been the traditional instruments of law and regulation. So as I say, this now means that technology is still out there, but technology is in here with us, with law and regulations, in our mix as well. It's in our domain, highly salient, highly significant. And the whole repertoire of technologies now being developed for law, for governance, legal tech, reg tech, law tech. The whole business is about using technical measures or technologies to do the work that law has traditionally done through rules and standards. So we have the prospect of law becoming an enterprise, not just as subjecting human conduct to the governance of rules, as Longfellow put it, but to the governance of rules plus various kinds of technical instruments, and maybe evolving into governance, to put it potentially in a dystopian sort of way, by machines. And that's really the direction of travel that I want to focus on in the rethinking, that we're heading towards new forms of governance, where if law and regulation are joined by much more technological forms of governance, what I refer to in a lot of my writing as technological management of the regulatory spaces. Instead of overlaying these spaces with normative codes in the way that law does, these are the rules that apply here in this space. We design the space or the products in the space in ways that give only certain options to people who act in those spaces. And international airports are a good example of what that kind of environment looks like. So you have rules in play, but you also have all sorts of technological devices in play as well, which are about governance of the behavior of people who find themselves in those spaces, who can enter. Anybody who's tried, having gone through an international airport to the departure area, and then try to backtrack to get out of the airport the way they came in, will find that the architecture doesn't actually encourage you to do that. So we have these three pictures, and the 2020s picture, as I say, is a very interesting one indeed, because I don't think there's ever been a time when lawyers without too much encouragement, have had to be very interested in what's going on with technology now. How do we begin to we're already a major exercise in rethinking, but how do we take this forward? So first of all, I'd say we have to think again about a clutch of concepts that we have around legality and the rule of law and legitimacy. Now, it's not altogether clear how these three, legality, the rule of law, legitimacy, how they relate to one another. But let's just focus on the rule of law, where there's a familiar debate. On the one side, we have, and the rule of law is about rule by rules. And all of this apparatus, I should say, is predicated on governance by rules. So the question here is how we rethink it, where governance isn't just by rules. Sorry, I should have made that clear. But with the rule of law, the traditional opposition is between those people who are taking a rather thin formal or procedural sort of view of the rule of law, equating it with legality in a Fullerian sense, where you commit to governance by rules. What does that mean you've committed to? Well, you've committed to, of course, having rules, but also to giving your regulatees or those who are being governed a fair warning that these are the rules and a fair opportunity to comply with the rules. These are the essentials, and the officials who administer the rules, of course, stick to the rule book. That's as far as the formalists or the procedurists want to go with the rule of law. They don't want to thicken it up with any particular substantive requirements beyond those procedural elements. The opposition, of course, comes from people who take a more substantive view, typically people who want to embed respect for human rights in the rule of law. So we have this traditional opposition, and I mean, and that debate still continues. I have to say that I'm very much with the substantivists in that traditional debate, and although there is a concern that once you embed substantive principles in the rule of law, you then make it more partisan, less neutral. My view is that we need to go right back to embed the deepest infrastructural conditions for humans to form communities, to exist on planet Earth, and well, even think about and question governance. In Josh Fairfield's recent book, Runaway Technologies, he talks about the conditions for the viability of humans, which is, I think, a nice way. I mean, he probably doesn't have exactly in mind what I'm thinking about, but I'm thinking about the preconditions, the most essential infrastructures for human social existence. We wouldn't be here, we wouldn't be what we are without these kind of conditions being in place. And, climate change and pandemics remind us that these infrastructural conditions really do matter. We neglect them at our peril. So this is what I think. It's respect for these conditions that really needs to be embedded in all versions of the rule of law substantively. And then I think each community can develop the rule of law in its own particular way, provided it does so in a way that's compatible with respect for these absolute preconditions, the platform for human social existence. But in the book and today, let me just flag up 4 ways in which I think we mustn't restrict the scope of the rule of law. So first of all, we have to ensure that the rule of law, although traditionally we think of the rule of law as being about governance by rules, it can't just be about governance by rules, because if rules are going to be joined by technical measures and technological instruments, we have to say the rule of law applies to those as well. You can't have governance being exercised by technologies or technological means as a bypass around the rule of law legitimating or legitimate framework for. So that's the first thing. The second thing is that, well, this is not new, but you can't give a free pass to people who are working or acting in online environments. The rule of law historically was about an offline world, as we now put it. But whatever the world we're thinking about, whether it's offline, whether it's online, whether it's some sort of hybrid of online and offline, whatever it might be, the rule of law has to apply there. The third thing is that, and this would be a huge pushback against this in some quarters, but we can't just have it that the rule of law is about public governance. It is about public governance, but it has to be about private governance as well. We can't just give a free pass to those who are particularly through the use of technological instruments, are actually in the forefront of governance by technology. So that has to be adjusted as well. And fourthly, we have to allow for the possibility that it won't be governance just by humans with their rules, but it will be governance by smart machines, by technologies, sometimes assisting humans, but sometimes working on their own. And wherever we are on that spectrum, the rule of law has to apply. So the rule of law has to be a comprehensive cover that gives legitimacy to these various forms of governance, whether the tools that are being used are rules or not, or technologies, whether it's public or private, whether we're online, offline, whether we're talking about humans being in or out of the loop. In all cases, the rule of law has to apply. So major amount of rethinking there. We can't just stick with this particular narrow debate about procedural versus substantive versions of the rule of law. We have to adjust our thinking beyond that. Now, having adjusted our thinking in relation to the rule of law, as I say, for each community, there are decisions to be made about kind of the constitutionalization of governance by technology. How far in each particular community are people prepared to see technology insinuated into the process of governance? And I would recognize that there'll be different views around the world about this. So I'm not thinking there'll be a uniform position on this. Whatever position is taken, it has to be compatible, as I say, with respect for the most basic preconditions for human social existence. But provided that's done, then I think some people could be more sort of tech friendly than, or more positive about technological governance than others. And we've got a lot to think about here. But I mean, the obvious sites for our thoughts are going to be in the criminal justice system and in the civil justice system. And I think of each of these systems as having both an ex ante and an ex post dimension to it. By which I mean that, in criminal justice, there's the period before crimes are being committed, and then there's the period after the crimes being committed that needs to be governed. And similarly with civil justice, there's a time before conflicts or problems develop into disputes, or before wrongs are done, and there's a time afterwards where again we need governance. So there will be some cases, and there already are, I think, where we think there are clear advantages in bringing technologies to bear on both criminal and civil justice. In civil justice, the UK is by no means the worst performer in relation to its civil justice, but here, as in many other countries, access to justice is a major issue. You just don't feel that we have an equal shout at getting access to justice. So what can we do to improve that? And of course, the possibilities of offering people online support and assistance, or online disputing, looks like a really positive step to make to widen access, to make disputing more convenient. Just like today, I don't have to be in Sydney to actually deliver this talk. It's not all good, but it does have some upsides, and it's not the most convenient. People who emphasize the convenience of online dispute resolution probably aren't thinking about people coming online to do their disputing at 5:30 in the morning. But you get this. You can see the obvious gains there, obvious pluses with that, there might be some downsides because people are not getting always their day in court, so to speak. But you might think this is a second-class form of justice. But I think that this is sort of something that looks overall beneficial. And then in criminal justice too, it's some time since we started, using tools like DNA profiling to assist in the detection of crime, there might be mixed reviews about this, but there will be. I think some decisions for communities will be easier than others, and I mean we see at the moment with debates about facial recognition technologies being applied for criminal justice purposes, people are getting a bit nervous about the extent to which surveillance technologies are being deployed in criminal justice or security contexts. But there will be some cases where communities, I think, find it quite easy to reach an acceptable position on this. But there will be cases where it's more challenging. And the two big questions that I think governance by technologies where there needs to be a really deep and extended conversation are about automation, first of all, which takes humans out of the loop. And secondly, about the emphasis on prevention rather than ex post reaction to wrongs and crimes, but just prevention, preventing disputes arising, preventing crimes occurring. Now, automation is, well, I'm assuming here that we're taking humans out of the loop. And if we're taking human decision makers out of the loop, I mean, that is a big deal. But, there's pressure to do this where you're dealing on the civil side with fairly low value disputes that we could just automate decision making there. But doing this in the criminal justice system is a bigger deal altogether, I think, because the stakes are, in terms of liberty and reputation, are higher. But again, I mean, we can automate in advance, ex ante, to try to take humans out of the loop by taking them out of situations where humans are accidents waiting to happen, for example. Or we can automate in transactions in ways that might ensure the performance, and that way a dispute is avoided. And there might be other ways in which we could automate in criminal justice to try to minimize the risk of crimes occurring. But I think wherever humans are being taken out of the loop, this you need to take a very hard look at this. I mean, even keeping humans formally in the loop is not enough. We know there has to be a real role for humans when they're operating with machines. Now, in relation to prevention, Richard Susskind, who's written a lot about technology, particularly on the civil side, says rightly, I think, that it makes sense to have a fence built at the top of a cliff rather than have an ambulance waiting at the bottom. I mean, prevention is, on the face of it, a very good idea, the best possible option. But the technologies that are deployed to prevent a crime or to prevent, what would be a tort otherwise or a wrong, but particularly crimes, at the moment mean that there's going to be very intense surveillance and possibly profiling, and then interventions which are designed to keep people out of certain places. Very, very intensive technological management, so that the opportunity for crime is reduced. And although on the face of it, this sounds like a really rational way of dealing with crime. If you want to control crime, stop it happening in the first place. The measures that are taken will need, I think, intense scrutiny. People worry, quite rightly, that the values that due process values that we hold dear in relation to ex post criminal justice just get diluted once we go into ex ante mode. We think in a different way about ex ante interventions. We think it's very easy there to think about this as just risk management. And with risk management, a more utilitarian way of thinking comes into play. So I think communities need to work hard at these kind of proposals for bringing technologies to bear on in a preventive way on criminal justice and in the civil justice area as well. Now, in the title of the talk, I flagged up authority and respect, and I just want to say a few words about this, if I may, before I wrap this up. That authority, we know, is problematic. I mean, we know this because, particularly in cyberspace, the early cyber libertarians challenged not just the authority of one particular legal system rather than another, on national legal systems generally. They were saying we don't see why we should have to recognize your authority in cyberspace. And Joe Reidenberg, again, talked about the internet separatists 15 years ago, what these people, once they think they're in online environments, the rule of law no longer applies. So the authority of law has been challenged there. But I want to look at this through the lens of respect. And I'm particularly interested in the claim that we should respect the law because it is the law, simply because it's the law. And crucially, even though we have reservations about the position taken by the law. Now, I think it's in that, where we're dealing with law as a human enterprise, humans governing and humans being governed, it's a perfectly natural question to ask, why should this group of humans who are in the role of governors have the right to tell me that this is what I ought or ought not to do? By what right? Which is taking it back to authority, but why should I respect their decisions? Once we say, well, why should we respect? It implies you do have reservations. And I think that respect is really just such an interesting concept where only where there are reservations in play, if people didn't have reservations about this, demanding respect wouldn't be such an interesting and strong demand. Now, there's a story, okay, when I was a young lawyer, young academic lawyer, the most important judge in England was Lord Denning. And consumers had a lot to thank Lord Denning for in his forays. But he was a judge who attracted, a mixed press. So, I mean, on the one hand, some people thought he was a hero because, he wouldn't let the law stand on the face of it, stand in the way of what he thought was clearly, what justice required in a particular case. But of course, that provoked a lot of opposition and criticism. The people said he just didn't respect the law, played fast and loose with the precedents. So in a very, in a famous interview, Denning was being asked about this question of whether he really did or didn't respect the law, and particularly his approach to precedents. And his response was, well, this is nonsense. Of course, I respect the law. I always follow the precedents where I agree with them. This is what he said. I always follow the precedents where I agree with them. Yeah, okay, so I always comply with the law where I agree with it. Jonathan Sumption, until recently, Supreme Court Justice, he has been giving quite a lot of talks recently. I've written a book as well where he's saying, that you should give more weight to your reservations. But the thing about respect is that Denning, you would say, didn't really understand the concept of respect because he thought that following the precedents where you agreed with them is good enough. No, the whole point is that you should follow the precedents or comply with the law, even if you don't agree with it. And that is why this is such a strong and interesting demand. So what would law have to look like to justify that kind of demand? And traditionally, we have two answers to that question. One is an answer which emphasizes the element of legality in governance by rules, that law brings with it order and predictability and calculability. And it's worse, the alternative, which is the kind of Wild West view, is worse. So that's why you should respect law, because law brings order. Now, the rival view to that, which sort of ups the ante, is, yeah, sure, law brings order, but the crucial thing is that it's backed by an aspiration, at least, for justice. It's not simply order, it's just order that law brings with it. And that's why we should respect it, because even if we have reservations about particular decisions, and of course, reservations about the way the trade-off between order and justice is sometimes negotiated in decisions, it's still better than the alternative. That's sort of the lineup in the traditional debate. So you've got a more substantive view on the order plus justice reason for respecting law. And, one view, the former view, the order view, you could say, well, that's appealing to prudential considerations, that if you value what's good for you, that you'll go along with the law. Whereas the latter view, the more substantive view, that we have justice as well, that's a view that that appeals to moral reason, really, that this is the right thing to do, to respect. But now, here we have the prospect of governance by machines, governance by technology coming along. And the selling point for governance by machines, governance by technology, is that they can do it better. They can do governance better than we humans can do it with our rules and whatnot. They can do it better. And it doesn't matter whether order is your priority or justice is your priority. The moral machines will do justice better than humans. and the other machines will do order better than humans. They can do it better. So how do we respond to that? Because now, there's a third kid on the block and claiming to be better than the previous models. So would it be better? And I know, Lyra, you've asked this question several times, and I know you're skeptical. And I mean, jury's clearly out on this at the moment. You've got to be better until you see how this plays out. You don't really know. But I want to say that yes, of course, we need to be persuaded. We need to have evidence that it really would be better. But I don't think that's the only objection. And it's a rather strange objection I'm going to come up with, but the reason to push back against this is that this isn't an improved model so much as a quite different model. It's something completely different. When we take humans out of the loop, when we take rules out of the loop, when we leave it to the machines, then that is a very different mode of governance. And I'm not, people talk about we want human-centric governance, and it may be that the machines, having sort of read Asimov on being programmed, won't harm us, and they'll kind of in a paternalistic way trying to look after our interests. But that's not the point. What's human-centric is that law remains an essentially human enterprise. It's not just the governance of humans by rules, it's governance by humans. And so we reached a sort of slightly paradoxical position of saying, yeah, we should stick with human governance, even though it's imperfect, even though in some senses the machines can do it better. But we want humans to be doing this. It's a human enterprise, essentially humans. Humans have to stay in control of this. And of course, that means that with humans still in control, we're going to have even more questions about why we should respect human laws or human decisions when people say, oh, but the machines could be doing it better. Never mind other humans, or we ourselves could be doing better. But the interesting thing here is that if we do hand over to the machines, if we decide governance by machines is the better option for us, then I think we do give up our reservations. We might still have questions. We might still be puzzled by some things the machines do, but we will know, because we've delegated it to the machines, that they actually do it better. And it's a bit like, the famous 5-match series when AlphaGo beat Lee Sedol at Go, the world champion human Go player, where professionals watching those games thought that AlphaGo made mistakes many occasions, and then realized that in fact, and in one particular very famous case, it was a killer move that had been played by AlphaGo, which no human would ever have played. So I think that with machines running the show, technologies running the show, we will have questions still, but they'll kind of confirm that we humans aren't as clever as the machines, that they do governance better. And one thing I would caution about our rethinking is that we should be slow to translate concepts like respect or authority or trust across from a world of human governance to a world of machine governance. The phrase trustworthy autonomous systems or something. I mean, there's a lot of talk about trust or again, people say, well, in relation to, I've seen people talking about online dispute resolution, maybe we'll have to change our idea of justice. Yeah, I think the translation of these concepts across to a very different modality of governance is something we need to be careful about. So to wrap up, Lyria, I hope that this will be in time. I'm taken back here to going back to when in London at King's we launched Telos back in April 2007, and that was a beautiful April weekend. It was the conference we held was on a Saturday, started on a Saturday morning with Lawrence Lessig, taking up the whole Saturday morning to talk us through code version 2.0, which had just been published the previous year, and went right on till late on Sunday afternoon. And Michael Kirby had kindly come across from Australia for the conference, and he sat through the whole thing right from the start, right to that late Sunday afternoon finish, and he then gave a masterly summary of all the papers that had been presented. But what sticks in my mind is that his remark. He said, I think there were probably 50 or 60 people there present. those people could claim to be individually experts in law and technology. The conference was called Regulating Technologies, and he said, collectively, most of the expertise in the world about law and technology was gathered at that conference in London. But the bar at that time in 2007 was very low indeed. We knew very little. And there's a long way to go. And so since 2007, been an absolute explosion of literature and interest in our field. It's really taken off in a fantastic way. I think, so we know more than we knew then, for sure. But what worries me to some extent is, although we know there's a lot we don't know, I'm not so sure that we're so good at knowing that we do actually know, that the things we know, but we don't realize we know, because we don't have hubs like Alan's, or, that can synthesize what we do know. That's one reason amongst many for thinking that it's fantastic that you have the hub now at UNSW, and Alan's have supported this. I'm sure it's the future. I'm sure Alan's is going to be a very big part of the future, and I wish everyone associated with it the very best of success in that future. Thank you.
Thank you, Roger. I was saying I remember the 2007 event, not because I could be there, but because I wanted to be there, but it was poorly timed with my pregnancy of my daughter. In any event, thank you for that presentation and all of the ideas you've raised. I'm going to start out with some of my questions and then move to some of the questions coming from the audience. So please keep adding those to the Q&A forum as well. The first thing I wanted to start with that I was thinking about as I was listening to you was, and it relates to sort of that idea of technology and governance, is the question a to what extent question or a how question? So what do I mean by that? So to what extent question is the humans on the loop question, right? So do humans need to be in the loop, deep in the loop, merely on the loop? And we can ask all of those questions about, to what extent do we let technology take over? To what extent does it have to be a human involved? Or is it really a how question? So in the sense as my colleague Martin Krieger might put it, how do we temper the exercise of power as sort of the entity controlling us moves from sort of rules and people and so forth, traditional forms of governance, to technologies? And I'm just following up a little bit on the how idea. One of the ideas that's become popular to at least talk about in Australia, not necessarily implement, and I know this has come up in one of the questions as well, is the rules as code movement. So rules as code is this idea that, okay, let's take legislation written in a language such as English. In Australia and in the UK, it's English. Let's take that and let's write it, humans involved, transparently rewrite that in a machine consumable format, in other words, computer code, so that we all know and understand exactly how this will be implemented by machines. We can check that the computer code that's written corresponds to the statutory rules, right? Because it's going to be transparent and public. And then we know exactly what the machines are going to do. And if any questions come up with their decisions, we can go back to that code and check it was implemented correctly and so forth. So rules as code is, if you like, a response to the how question. It says, well, we're happy to let technologies go, but we want to put transparency controls, accountability controls around that process. We want to answer the how. But then we'll do it without humans staying in the loop. Whereas I was unsure if you're more interested in the how question or you're really focused on the to what extent question and the need for humans to be involved independent of what other systems one might put in place.
Yeah. Well, thanks for that question, Larry. Yeah, I mean, there's a lot to engage with there, actually, isn't there? And I wasn't thinking actually in either terms of the extent or how. I mean, it depends which kind of legal and regulatory functions you're talking about, I think. And yeah, to start with, I mean, there's an awful lot of nitty-gritty question about how humans might best be kept in the loop, or how we might best join humans and machines in working together. For example, this isn't not an example from law and regulation as such, but the other day there was a meeting of the UK National Screening Committee here that I was listening to, where we're thinking about how AI might be introduced into the screening pathways that we have, particularly for reading images for, say, breast cancer. So at the moment, we have 2 humans reading images. And if you say, well, how might we now integrate AI reading? I mean, it could be just AI takes over and we just leave it to AI to read the images. But suppose that we're having humans working with AI. Do we start with AI? Do we have an AI reading first and then a human reviewer? Or do we start with a human reviewer and then have an AI and then there's a second human? I mean, there are any number of permutations there, some of which might actually work much better than others, who knows? Just like, again, with nowadays in sports, where humans are working with machines in making off-pitch decisions about, VAR and so on. What's the best way of, the interaction between the human official or referee on the pitch and the official off the pitch? What's the best way of doing that? So I think those are really nitty-gritty questions, but you're asking more, I think. Well, and sorry, the question about humans working with coders on assuming that humans are responsible for legislating rules in the first place. Now we hand over to the machines to try and make machine readable versions of the law. How do humans best stay on the case with that? I'm thinking about. Let's suppose you think about the automation of road traffic offences, so that road traffic offences are detected automatically and processed automatically. How do humans stay in the loop on that? Well, they're not actually there in the foreground anymore. And the crucial thing there will be going back to what I was saying about the rule of law. We need to have ground rules set down that constitutionalize certain sorts of operations. And it may be that before we hand over to automation like that or to technological management of a space, there has to be an approval given that this is a license given for it. And then the license having been given, humans don't show any more in that. I don't know. I mean, we're struggling, aren't we? Because in Europe, the GDPR Article 22 is cautious about solely automated decision making, where it's legally or other ways significant. And but to my mind, it is posing questions rather than giving us the answer. I think just the way I'm struggling to formulate a response to your question, it reveals that I don't already have a frame. It's not like you could ask me questions about all sorts of things where I've heard that question before, and we all have a kind of frame through which we say, okay, this is the way we organize our thoughts about this, instead of coming at it in a scattergun sort of way that I am right now. Would say, these are the thoughts that occur to me. But so I think that's a really great question. Yeah, the question of and just framing it in terms, is it extent or is it how, points us to possible applications that we need to think hard about. Yeah.
Okay, thank you, Roger. That was quite a long question, so perhaps unfair to put you on the spot, but I appreciated your answer to it. So thank you. Got some great questions coming in from the audience. So I'm going to sort of work with those a little bit. So one question is sort of really asking. The question itself is AI, blockchain, or any other machine learning tool used in law to make it more efficient? But I kind of wanted to play off that question a little bit and sort of say, well, when we have rules, when we have the sort of rule by rules, which is sort of, the written text from the traditional forms of governance, does it matter if those rules are themselves formulated using some kind of AI technology to ensure that the rule set is efficient? In other words, are you concerned about technologies at that pre-rule step or more in the enforcement phase?
Oh, yeah. Well, I would be concerned about AI, I suppose, in the pre-rule stage as well. Yeah. I don't mean categorically say that we should prohibit this, but no, I think any application of AI is something that we need to. Yeah, I mean, we need to wonder about. Yeah, it's true. I mean, I suppose it's true that most of our questions have been raised about the use of AI in the enforcement of the rules, so the decisions being made within a rule framework that's already been put in place, like again in criminal justice, where you're talking about decisions being made about bail or whatever it might be. So we have some sort of profile of a person that the AI gives us, and like insurance companies, I mean, all the usual things that. Where we already have a rule framework in place, but in principle, yeah, But again, I mean, kind of modelling of the way laws would play out in practice, and using AI for that, I can imagine that that could be very informative. But I suppose the question again is to what extent we just become reliant in a mechanical way on the technology because we're so convinced that it's smarter than we are. And if it's indicating that this is the way we should be going with a particular law, then, we're going to follow it. And that kind of bias towards the technology just becomes part of our mindset.
Okay, thank you. So the next question actually follows on from your 3 pictures in time point that you began with. The question says, so I note that technology has been hugely democratized since the mid-90s and not anymore reserved for the few. Do you think this is further reflected in the legitimacy of technology governance? So at the same time, human agency has become relevant. Technology has been serving different purposes throughout time. 1960s resource allocation, 1990s communication, currently automation. So have those changes shaped expectations from technology governance? In other words, to what extent are your ideas shaped by the changes that are simultaneously happening in the types of technologies we've seen through that time?
Yeah, well, I think that's right, that during that time, from the 90s onwards, different technologies have come into the spotlight, and we've seen different potential there. I mean, it's interesting that, if I can just in an autobiographical way say, when I first read Lawrence Lessig's book on code, which is really, it's all about IT, of course, and computers and software, and the way that coding can have a governance function. I mean, at that time, my interest was mainly in biotech, and I mean, my thinking laterally, my thought straight away was, although we don't think about we think we're a long way from understanding the way genetics might shape human behavior. And we're just beginning to unravel, the secrets of genetics in relation to human diseases or disorders. Suppose that we were, some future time, able to understand the human coding in a way that would allow us to tweak it to change behavioral patterns. Then this would be directly parallel to the coding of software. And but I mean, that seemed a long way off. But coming up to the present day, it seems to me that I've never seen so much interest from lawyers in tech as has been generated by AI. That really seems to me to have been the game changer here. The fact, and of course, the early examples of AI being applied by decision makers. To get a steer on sentencing or on bail, again in criminal justice, to think about how resources can be best allocated. These are that really does seem to have been a game changer. That there's a stream of technology here that now does really look as though it has possibilities to take on governance functions and not just assist in the way that surveillance or sensing technologies can assist. And yeah, so that has, I think this is a good question, that the particular developments in technology which have captured our attention are ones that do change our expectations about how far tech can actually play a role in governance. Yeah, that's quite right.
It actually leads into another sort of comment and question from the audience, which is that a lot of the concerns about AI and maybe explaining some of the lawyers' fascination with it is the sort of particularly the material coming out about sort of, super intelligence, human level intelligence, or machines that are sort of replacing humans, and the role of humans then in that system. And I think your work certainly, not necessarily dealing with that level of AI. I think you're dealing with, even quite, basic functions even can replace humans in certain governance contexts and so forth. But to what extent, I suppose, do you reflect on sort of that strand of the literature, the AI that's going to be, so smart that it'll, be absolutely brilliant, etc., and what that might mean for the sort of arguments you're making about, rule of law, legitimacy, and one might also add, human rights, as the questioner does as well.
Yeah, absolutely, Larry. Yeah, so if we're thinking about super intelligent AI, general AI, that the one response to that concern is that the AI might treat us rather well. Super intelligent beings might treat us, as I say, in a paternalistic sort of way. We're not center stage anymore, but we're a bit like humans treat some of their pets, rather kindly. That we might be treated in a similar sort of way. Alternatively, of course, it could be that the super intelligent AI has no use for us anymore, and we're just treated as things and tools which can be deployed in ways that suit that particular super intelligence. That's just thinking about Nick Bostrom's concerns there, or again, Stephen Hawking saying AI could be the best thing ever for humanity, but also could be the worst thing, and that sort of scenario. Now, I think when I'm saying that we, above all, as humans, have an interest in maintaining the preconditions for our human social existence, this does sort of assume that we do remain center stage and in control, because if we hand it over to superintelligent being or superintelligence, then we're no longer making our own decisions. We're changing the context for our own autonomous decision making, I think, or restricting the space in which the opportunities we have for that. And a superintelligence telling us what's right and what's wrong, even if we agree with it, it's not us freely coming to that view. For a long, and it's still today, but for a long time, I was absolutely obsessed with. Karen always used to tease me about this, but I was absolutely obsessed with the idea that what made humans really the best and worst of beings was that we could only do the right thing if we had the opportunity to do the wrong thing. It's very important that doing the right thing was done freely for the right reason. And once you've got a super intelligence running the show and dictating what's the right thing to do, then, and you have to do that, then you can't claim any credit for doing the right thing. Like, Ian Kerr, the late Ian Kerr said, there's no virtue you can't automate, virtue. You can't. So, I mean, it sounds terribly old-fashioned and sort of conservative, but I think we do have to be careful with, particularly with this idea of human centricity, that we don't mistake it for, a concern about humans being harmed. Of course, we don't want AI that kills us or that is dangerous in that way, but it's to do with. Murray, in the blurb she kind of wrote for the book, says that I wish I'd thought of this, but she says, human imperfection is not a bug; it's a feature, according to me. Well, I wish I had thought of that, because that just captures it brilliantly. But it seems such a bizarre thing to say. Well, human imperfection is something that we should prize. You know, the opportunity that humans have to do the wrong thing. Come on, but that seems to be the path that I'm being led down. Yeah.
Look, Roger, thank you for that, and I love that quote. That's fabulous. I think that one should be deployed in all circumstances. Look, thank you. As I said at the outset, I love the fact that you're thinking about these issues and forcing us to think about these issues as technology is increasingly used to manufacture law, to implement law, to prevent us breaking laws.
Yeah.
You know, what does that mean? What are the implications, and how do we think about that even before we get to superintelligence, even when the technologies we're using are more a la robo-debt, which is always the Australian example. So thank you for helping us to think about this. Thank you for waking up so early in the UK and being with us here in Australia. Thank you to everyone else involved. Thank you to Andrew and Gavin for their kind introductions. Thank you to everyone for coming along. Thank you to those who asked questions. And I'm sorry we couldn't get to all of them, but very much appreciated. Good night.
Thanks, Lyria. All the best.